There were a lot of good questions about standard form interrogatories, so I thought what I would do is quickly go through your questions and see if I can't give you some other information. Alicia asked a cool question about what effect do crimes a person has been convicted of have on these proceedings. And generally, after a period of time, you can ask about a criminal conviction, and I believe 10 years is about the limit. But if you've been convicted of a crime of false swearing or they're called, this is the legal term, and I don't know the English term as it were, but it was known as a Latin term crimen, C-R-I-M-E-N, falsi, F-A-L-S-I, a crime of giving false information after you're sworn. So it's something like perjury or lying under oath, whatever it is. You can always be asked about that, and it can always be brought to the jury's attention that whenever you were convicted, you were asked questions under oath, swearing to tell the truth as you are today, and in that instance you did not and were found guilty beyond a reasonable doubt, so you can always bring that up. Our other question is about weather reports, and yes, weather reports are always significant for everybody in the case, particularly automobile accidents. Colleen asked a good question about do defendants sometimes surveil plaintiffs? Yes, in fact they do. And I have some limited experience with that. I was once involved in a case where a man was claimed to be disabled. They sent an investigator to videotape him from a distance. What the investigator did was go and let the air out of one of the tires of his car. Unknown to the investigator, the man had a doctor's appointment, came out, and there was a flat tire. He did, in fact, unload his spare tire, set up the jack up the car, pull off the tire, replace it in his trunk, put the new one on, tighten the bolts, and then drive off. And the defense introduced that, or attempted to introduce that at the trial. What happened, though, afterwards was that the man had undergone such stress as a result of that, went to the hospital, and was immediately admitted to the hospital as a result of the new injuries he'd suffered changing the car tires, and eventually the plaintiff in that case brought an action against the insurance company which had paid the defendant. Colleen also asks what use of social media. Everybody, social media, and this will make you more valuable, assuming you're younger and hipper with social media, say, than me. It will make you very valuable to a law firm. Many people in law firms aren't entirely hip to what social media is, and there are a million cases already about people being on total disability, having pictures of themselves zip-lining or jumping on what do you call those things that bounce up and, jumping up and down, doing playing softball, playing touch football, doing all sorts of things that a person who is disabled cannot. And yes, they can ask about those and use them against you if you do have items like that on your page. Let's see. Andrea asks an interesting question. Do you have to answer a question if it's embarrassing? If it's embarrassing, that's probably not a grounds to answer it. If it's burdensome or if it tends to be prejudicial, then you might ask the court. But for the most part, they're going to make you answer any embarrassing questions. Sorbel asks if people can ask you questions about whether you've been involved in previous litigation. Yes, they can, and yes, they will closely track that. They want to know if your claim today has any similarity to a claim you may have filed in previous occasions. Of course, they're looking for a pattern of those sorts of cases. When you start litigation, you almost have to be careful what you ask for because they can ask about a lot of things. Oftentimes people will put in a claim that their spouse lost the value or the benefit of their services, both personal, sexual, husband, wife, you name it. They can ask you the most personal questions you can imagine about that. So be prepared if people ask that, and be prepared to let people know that this is what they'll be facing. Slip and fall cases, do they go to trial? I don't know the percentage. There's not a percentage, but yes, they do. I can tell you that when some companies owned casinos in Atlantic City, they would never settle a slip and fall case. So yes, they do. Again, this is T-Ray's question about can they ask about prior cases involving personal injury? Yes, they can. Number 2 is an interesting question. Can they ask whether you fixed something or not? So say I went down a flight of steps and claimed that the steps broke and I fell as a result of that. Could you come back and say, did you fix those steps? And if they did, use it against them? You can't use it against the defendant if they actually fixed a problem that was wrong. The reason you can is because it would be an incentive not to fix it if it could be introduced against them. Does that make sense? So you don't want to punish a defendant for doing the right thing, so you can't use after repairs against someone if they fix something. And again, T-Ray asks the same question about being able to ask questions about criminal convictions. Again, criminal convictions involving false swearing of any sort can always be brought up, is my understanding. Antoinette asks again a question of violations of city ordinances. Yes, you can bring those up. Those are important because usually an ordinance sets a standard of care, and a violation of an ordinance will often be deemed to be per se negligence on the part of a defendant. Antoinette asks a question about can they bring up the fact that you repaired a situation after somebody got hurt, and generally no, they can't, because we want people to fix things to make them safe for the next person. Liz asks liability coverage. Yes, that's also important. Oftentimes, plaintiffs want to know what defendant's insurance coverage is. Trust me, everybody. If remember that $9 million case we found? If that person doesn't have substantial $9 million worth of assets or some sort of insurance that might cover him, that case may not be one worth bringing, because you're going to get a judgment, but there won't be any way to collect it. So questions about insurance coverage. Remember, the standard for whether a question can be asked is not whether it's admissible at trial, but whether it could lead to information that could be admissible. They'll always let insurance questions be asked in discovery, because that is an important part of resolving a case. Liz asks another question about the people responsible for cleaning a site. If you get an expert who determines that the condition of the site was made slippery by virtue of the cleaning personnel, that may add another couple of particular defendants, and you're always looking for other people to bring in if you're the plaintiff. Again, Liz also asks about social media accounts, and yes, those are always capable of being discovered. Nick again asked about previous accidents. Asks about previous convictions. Again, those can be asked. He also asked a question about who had control over the premises. And yes, if someone, say a management company, had control, they would be a separate party that would also be responsible. Videotaping on the day of the incident. Yes, you always want to know what was done by the other side in terms of photographs of the scene or videotapes of the scene. Oftentimes the companies will have trained security personnel that will approach an injured victim at the scene and try and get them to say, oh, I wasn't looking, or I wasn't careful, or I had 14 drinks. Things that are going to try and preserve the claim by the by the defendant. So those are not uncommon, and you want to get those in discovery because you'll be seeing them at trial, so you want to see them beforehand. Sandra asked a question about people that were present. Yes, additional witnesses. You're always looking for additional witnesses, and you'll always ask who has knowledge of this case. You'll always refer to that if at trial somebody hasn't told you about a new witness. New witnesses shouldn't ever happen, everybody. They've got to tell you about it before the case proceeds any further. Again, social media accounts Sandra asked about, and yes, they're everywhere, and they're always going to be asked about. People responsible for maintaining and cleaning are always going to be required to be disclosed. You're always looking for a new kind of defendant. Also a question about surveillance and social media, and I think we've addressed those already, so Kumo's on the right path. People that have knowledge of information, oftentimes folks are kind of funny about wanting to answer those questions, but you know, if you live alone, say, or if you live with a parent, say, oftentimes people will come home and tell those people what happened. So it's often common that you'll need to disclose that. Again, photographic surveillance done all the time. Social media accounts, again, kind of common. Brittany asks about was the property leased, who last maintained and cleaned it. Same questions that others have come up with, and again, same answers. City ordinances, Amanda asks about who spoke to, anybody speak to the parties. You always want to get those folks because what you're looking for, and we'll get into this perhaps later in this session, are admissions. Admissions are statements that are against your interest. So that if you get in a big accident and you get out of the car and you say, boy, I shouldn't drive anymore, I can't really see, or I shouldn't have had that fourth drink, or something that's against your interest, that can always be introduced against you as an exception to the hearsay rule. And essentially, that's the extent of our questions, everybody. I just wanted to provide some information.